Any mention?
Lordship, I beg to mention item number 5 of the main list, Lordship. I'm praying if this matter can be taken up on Monday, Lordship.
Lordship, we have already exchanged our written.
Lordship, the written submissions notes have been exchanged. However, Lordship, they have raised certain
In the
points
written argument, it is up to Lordship whether to take that into consideration or not.
Lordship has some submissions to be made, Lordship. I'm praying, Lordship, if it can be fixed on Monday.
I wonder.
It won't take long, Lordship. Only reverting to because there are certain new facts that has been.
But you have not.
Here, Lordship.
I have already given my written argument.
Have you made your?
Yes, my lord.
Oral submission?
No, Lordship.
Yes, Lordship. Oral also finished, written also finished. After they have given the written, I have given the reply, and thereafter they want to again file a rejoinder to whatever I have given. So
Lordship,
I don't
If I
understand.
recollect, Lordship, my learned senior Lordship has only filed his written submissions. There was no oral arguments.
Or my lord, oral argument has concluded. Thereafter, they had filed the written argument. Then I had taken 2 or 3 weeks, and I was getting caution
Lordship, may I have
to
it on
file
Monday,
my
Lordship.
written.
Will clarify, Lordship.
It's up to Lordship.
Monday, Lordship.
Yes, I mean unnecessarily dealing the matter.
Monday, Lordship.
My lord may reserve. In the meantime, if they want to file, let them file, my lord.
Since prayers me, last chance.
Lordship.
Made by parties by Mr. Leonard Counsel of the petitioner. This is matter of the 1 week. No more.
Please, your lordships. Lordships, I beg to make a mention of item number 7 from the daily list, lordships. This is a joint request, lordships.
It's only question, Lordship.
2022 matter.
Lordships. It's a cancellation of patta matter, lordship.
For
Lordships,
three,
may I have-
respondent 3 and 4, Your Lordship. On behalf of Mr. Pierre Pasque.
On made by parties. This is matter of the 1 week.
2 weeks, lordship.
2 weeks.
Highly
For the time.
Lordships. Highly obliged, lordships.
Please, your lordship. So I beg to mention item number 11, madam. I've taken the consent of the other side. It may kindly be taken up after 2 weeks, madam.
It's also old matter.
Yes, madam. Item number 11.
11. 2 weeks.
Much, madam.
Your lordship. Supplementary list, item number 1.
This is bail application, my lord. Inadvertently, my lord, the brief is not with me. If it comes at the bottom of list, my lord, I'll prepare myself.
We have supplied petition copy, Lordship, to the...
Without annexes.
Lordship.
End of the board.
Lordship, I'm deeply obliged. Deeply obliged, Lordship.
Item number 2.
Oh, no.
It's not mine. That item one also is yours. They're not considering.
Who is him? Please, Your Lordship.
This matter will list this matter tomorrow. Take it up now. It's tomorrow.
Deeply obliged.
From daily list, item number 1.
Yes, who's appearing here?
But
What's
this is
taking
an
so
appeal
long?
against the order of conviction. The accused was primarily
Yes,
charged
but
under
admission.
302. Well, let the appeal be admitted, my lord. We'll prepare the paper book. If there was a condemnation, my lord has already condoned the delay.
Granted.
All right.
Item number 4.
My lord, in this matter, we was directed to file our affidavit. We have already filed our affidavit today, and we have served a copy to them, my lord.
My lord, I'll go through if required. I'll file rejoinder.
What about respondent 6?
Number 6, my lord.
They will not file affidavit.
They're not filing.
Whether they have prepared?
Not yet filed.
No, no. Mr. Hassan was appearing. I don't know now what is the fate, whether he will continue to appear or not, my lord.
Because he's appearing for the acting Gambura. Now his term is only for three months. That has already been expired.
Oh, it's filed.
Yeah. Otherwise, there's a status quo order passed by your lordship. I'm continuing as a Gambura.
No, no, my lord. That is not a correct way.
There's
A new
an
Gambura has been
order.
appointed. A new Gambura, my lord, may kindly see my affidavit that I have filed. My lord, may kindly see if my friend is ready
No, but
to.
if there's a status quo order, then
No. In a connected matter, my lord, there was a direction of the Honorable High Court to go for to reinstate the previous admin, my lord. There was a direction of the coordinate bench, my lord, before he got a status quo order, my lord. So, my lord, may kindly see page 15 of my affidavit.
What's that interim order?
I'm done. Okay. Order C. Fine. Mr. D, when have you filed your affidavit?
Today, my lord. Just
It has not come on.
then let it come after a week, my lord.
Let it come after 2 weeks. I'll file my rejoinder if necessary.
If you get, yes, you have given him copy.
Yes, yes.
I've received a copy.
But I'll not note down that because your affidavit is not on board.
Yes, 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 my lord. We have already filed it, but my lord.
On pre-made by parties, this is matter to 2 weeks.
My lord.
Item number 6.
Yes, what is quite here?
My lord, this matter, the issue herein is, my lord, this is the third round of litigation, my lord. The issue herein is, my lord, what has happened before I open the facts, my lord. On the first round of litigation, my lord, the petitioner herein, my lord, was a constable in the BSF, my lord. And thereafter, a vacancy arose, head constable, my lord. So he appeared in the exam, cleared the exam, and he was transferred to Bengal, my lord. But his appointment to the head constable was not, my lord, supplied to him. He was made to sit for more than 6 months, my lord, without any reason being, my lord, given to him. So, my lord, at the end of 6 months, my lord, he was given a order saying that he has to go and get back his constable post. He is not fit for, my lord, head constable, for the fact that he had, my lord, during the medical examination, my lord, it was revealed that he had become a victim of HIV, my lord. So, on the sole ground of this HIV, my lord, his, my lord, medical status was, my lord, brought down to shape 2, my lord. Otherwise, he was shape 1, my lord. So, challenging that, my lord, for rejecting his promotion, my lord, on the first round of litigation, my lord, an order was passed by this Honorable High Court, my lord, that he should be given, that a person of HIV, my lord, should not be discriminated and my lord, it cannot be shape 1 cannot be brought to shape 2, my lord. So my lord, he was given the promotion. Then it so happened while he was given the promotion, my lord, his seniority was calculated from the date of joining instead of the date he was selected, my lord. So second round of litigation again came up, my lord, for fixing the seniority, my lord. So thereafter, in the second round of litigation also, my lord, an order was passed by this honorable court that his seniority should be, my lord, calculated from the day he was, my lord, got selected for the post of head constable, my lord. Now this is the third round of litigation, meaning thereby, my lord, by challenging the order of the, my lord, authority, my lord, he has attracted on himself the wrath of the mighty ones from the department. Now, what has happened, my lord, is subsequently in this third round of litigation, my lord, why petitioner is before your lordship, my lord, that during when the, my lord, promotion departmental, my lord, promotion committee set, my lord, his juniors superseded him, my lord. So it only points to the, my lord, the arbitrary and, my lord, biased attitude of the authority, my lord. Now in this case, my lord, the present case, my lord, I am ready for hearing, arguing this matter, my lord. On the last occasion, I had argued the matter, my lord, because, my lord, his initial appointment, and, my lord, his promotion, calculation of seniority, those are admitted facts, my lord. So here, my lord, the issue is only very limited to the extent that, my lord, superseding by his juniors, my lord. On the last occasion, when I had opened the argument, my lord had pointed out to the fact that each and every statement I had said that, like, I was appointed in the year 1992. That copy of the appointment should be brought on record. So, my lord, at this juncture, my lord, because petitioner is from, my lord, is in other state, my lord. So, my lord, I am unable to, my lord, get all the documents as of now, my lord. If I can pray for a week time, my lord, I'll compile all the documents, my lord, and so that, my lord, I can give an effective, my lord.
But why you have not done that when initially you had filed the petition? All those things should have been.
Yes, my lord, but the affidavit.
Basic facts should be there.
Yes, affidavit reflects that it is not disputed, my lord.
Not disputed.
Not disputed at all.
But have you stated anywhere that you were appointed in 1992?
Yes, yes. If my lord will accept that way, my lord, I can.
If the respondent is not disputing,
My lord.
if it is stated in the affidavit or at the bar, the court will accept that.
My lord. So in that situation, my lord, I can put forward my.
Honestly, why should if it's not a point of dispute?
My lord. Then, my lord, I can continue my hearing now. My lord.
Yes, who's appearing for the respondent?
Lordship, if I may interject, the senior counsel is currently engaged in court 1, Lordship.
So, my lord, in that situation, my lord, we can have it next time.
After a week. After a week. Or prevailing parties, this is matter.
Deeply obliged.
Item number 8.
You are supposed to file a short affidavit, Lordship, on the previous submission. Can you allow us 1 week's time, Lordship? Responding 3 to 5, Lordship. Liberty was granted for us to file an affidavit.
You have not done.
Lordship, this requires just 1 week's time, Lordship, and file it positively.
You are responding?
3 to 5, Lordship.
Your Lordship, let this be the last time, Your Lordship.
Mr. Learned Counsel for the respondent 3 to 5 has sought for accommodation.
Last opportunity may be given, Your Lordship.
On the ground that the affidavit which is required to be filed could not be done so. 1 week
1 week's time, Lordship.
on premier. Seems allowed. This is matter to 1 week. I miss appears for the petitioner.
Item number 9.
Challenge to the order of CM, Lordship. Issue of Patta cancellation.
Who's appearing?
Senior counsel Mr. Siddiqui was.
This is matter to 1 week.
Obliged.
Item number 10.
You don't read petition.
No link to the service report. No. This court, by order dated 21/4/2026, had directed for issuance of fresh notice upon the one of the petitioner, in this case, that is Sri Nikista Nongrang. Next, office note would show that notice has been issued accordingly. However, no service report has been filed in this regard. Accordingly, the service report is awaited. This is matter to 2 weeks.
If I may pray for closing the matter, Your Lordship, because Your Lordship, from the earlier council was there, they have withdrawn, Your Lordship. They have withdrawn. Notice have been issued, Your Lordship. Lordship, because this is an unregistered organization. Other petitioner they have received the notice, except the one that is petitioner number 8, Your Lordship. So they are in the know, Your Lordship, of the proceeding before this honorable court.
Who is appearing for?
Earlier, nobody appears, Your Lordship. After the withdrawal of the earlier council, Your Lordship, on 4/9/25, Your Lordship, till date nobody appeared, in spite of the fact that notice had already been served to the other writ petitioners, Your Lordship.
I think Mr. Sincon had appeared.
Initially, Your Lordship, he withdrew, Your Lordship.
Is he here?
Lordship.
Can understand from him whether he has contacted the petitioners, whether they, to that extent, that we can call.
Because if I recollect, Your Lordship, his withdrawal is in view of the fact that he has no contact with the client.
You can just summarily,
let the matter be closed, Your Lordship. If they are interested in pursuing the matter, they'll come and file an app for restoration, Your Lordship.
We'll see next date.
Lordship. Ask Lordship, please.
Second call from supplementary list, item number 1.
You got the file?
Yeah.
From where you got this file?
Judgment? No, I got from the petitioner side.
See, I just want to request the council here, because you know the sitting of the court. Sometimes there's a DB which I have to sit firstly, but because of so that we should not waste time.
My lord.
Sometimes the DB sits a bit late, then you sit in single. But I can understand that sometimes information could not be passed on to council.
My lord.
So some of them may not appear. Some of them.
My lord.
That what can we do? If I have to sit first in DB, then wait for single.
My lord, by now, my lord, almost all the lawyers, my lord, they are used to this, my lord. So, my lord, I don't see any complications, my lord. It is a silent understanding, my lord.
Even today, also some of the matters nobody has appeared.
Exactly.
Because they didn't anticipate that
My lord.
single will sit first.
But however, my lord, it is our duty to be here in the court by 10:30.
Yeah, right.
True. That's just, I'm just.
My lord is very kind, my lord.
Requesting the lawyers to accommodate us. Otherwise, what can we do?
My lord.
Yes.
May it please, Your Honor. Lordship, Lordship, this is a bail application, Lordship. There was an FIR dated, Lordship, 22 August 2025, Lordship, which is at page number 15 of the writ petition, Lordship. What had happened here, Lordship, was the accused person before Lordship was arrested merely on the statement of the co-accused, Lordship. Lordship, as per the FIR, Lordship, one person was arrested,
Yes.
Lordship, by the Clariat police, and then during investigation he made a statement that there is another person involved in the matter, and subsequently the accused before Lordship was arrested, Lordship, merely on the statement of the accused person, Lordship. Now, after he was arrested, Lordship, then there was charges were framed, Lordship, and initially only section 8C, 21B and section 29 of NDPS Act were invoked, Lordship. But later on, Lordship, will see, kindly see, Lordship, in page number 27, Lordship.
Page 15 is the FIR.
Lordship, 15 is the FIR, Lordship. I'll go through the FIR, Lordship.
Yes.
With reference to the subject cited above, I beg to inform you that today, the 22 August 2025 at around 11:15 a.m. received credible information to the effect that one drug peddler by the name Sri Niku Roy was travelling from Assam side towards Shillong. Immediately on receipt of the information, a Naka vehicle checking was set in front of Umkiang Police Patrol post on the National Highway 6, and at 1:30 p.m. one Tata Sumo white color BR number so and so, driven by Mr. so and so, 40 years, son of so and so, resident of Assam, coming from Silchar side was intercepted, and on checking inside the said Tata Sumo, the suspect, namely Sri Niku Roy, so and so years, and son of so and so, temporary address Lumparing, Shillong, East Khasi Hills, was found sitting at the last row of the vehicle. And later, after the arrival of police GO and independent witness, a search was conducted, and during the search, so and so numbers of soap boxes containing yellow-orange color powder material suspected to be heroin from his luggage bag were kept along with him in front of his seat. Later, a simple sample was drawn and preliminary test was conducted using NDPS kits, and the results showed positive for heroin. Weight and measurement were done using a digital weighing machine, and the net weight is, how much is the net? 23.91 grams, including plastic. The recovered suspected contraband were seized in presence of the witnesses. After completion of the observing necessary formalities, the seized suspected contraband was packed and sealed in the presence of independent witnesses. The entire operation was conducted under videography and photography. Therefore, we requested that the case may be kindly be registered under the appropriate sections of the law and NDPS Act against the person involved, Lordship. This is the FIR, Lordship. One person was arrested. After he was taken into custody, during investigation, he revealed that another person was involved along with him, Lordship. And based on that statement, Lordship, the accused person who was before Lordship was arrested, Lordship. Now, the charge against him was, Lordship, the factum of his arrest, Lordship, has been reflected in page number 25, Lordship. I'll just read out. Based on the statement of the accused person, Sri so-and-so, a team of Umkiang Petrol Post led by Sri so-and-so, IPS Assistant Superintendent of Police, is Jaintia Hills District.
Page 25?
Page 25, Lordship. Last paragraph, Lordship. A paragraph above the last paragraph, from the bottom.
Okay. Yes.
Lordship has it, Lordship. Based on the statement of the accused person, Sri Niku Roy, a team from Umkiang Petrol Post led by Sri Saurabh Kumar Saini, IPS Assistant Superintendent of Police, is Jaintia Hills District. Another person, namely Sri Ravi Gupta, was apprehended from Shillong for interrogation, Lordship. It was only subsequently that the accused person was arrested, Lordship, merely on the statement of the co-accused person. Lordship, the charges, one of the charges, police at a later stage, Lordship, has invoked section 27A, Lordship. Initially it was not there. It is clear from the charge sheet also, Lordship, that section 8C, 21B and 29 has been reflected, Lordship. But Lordship will kindly read section 27, page number 27, Lordship. If Lordship may kindly have page number 27.
Yes.
27, last two paragraph, Lordship, that during the course of the investigation, it is learned that arrested accused person so and so provides money or resources to support the illegal trade of drugs financing, and it is found that he is liable to be punished under section 27A NDPS Act, Lordship. It was a later stage that this section 27A was invoked, Lordship. Now, what is the factum of financing, Lordship? Factum of financing, a mere one deposit cannot amount to financing the deal, Lordship. But it's the case of the police, Lordship, that Lordship will kindly have, Lordship, page number 26, the facing page, Lordship. I'll just read out. First, 1, 2, 3, 4, 5, 6. Sixth bullet point, Lordship, the page number 26.
Yes.
On perusal of bank statements, it reveals that the accused person actually deposited cash on 17th August 2025. They had deposited an amount of 1,15,000 only through ATM situated at Laban Junction, Shillong, in account number so and so, maintained in the name of one Mr. Salimuddin, village so and so, Karimganj, Assam, using mobile phone number so and so. Lordship, this factum has been reflected in the charge sheet, Lordship, but in the entire case, Lordship, there is no record of where this person is, Lordship. If the version of the police is to be believed, this person is the mastermind of the whole thing, Lordship. Because in his account, allegedly the money was being deposited. Money was deposited, Lordship. He has not been arrested. There is no investigation with regard to this person, Lordship. So the statement of the police, the version of the police cannot be corroborated, Lordship. This person, so in whose account the money was deposited, had been arrested, Lordship, it could have been corroborated whether the money which was arrested, deposited, if at all, and for what purpose it was deposited, Lordship. Mere deposit doesn't amount to financing the deal, Lordship. That's the plea, Lordship. And Lordship, page number 27, I'll again take my Lordship to page number 27, Lordship. There is one note, Lordship, fourth paragraph, Lordship. The whole,
yes.
It is mentioned that here that during seizure of the CCTV footage, which was stored in the USB pen drive, on being produced by the technicians, Mr. So-and-so, Lordship, got it? First, second, third, fourth, fifth paragraph, bullet point, Lordship. Listen, there are two notes, Lordship. The second note, page number 27.
It is to be mentioned.
It is to be mentioned, Lordship. It is to be mentioned here that during seizure of the CCTV footage, which was stored in the USB pen drive, on being produced by the technician, Mr. Rajat Rizal, during seizure, the videography and photography was recorded / taken by Head Constable so-and-so using mobile phone and stored in SD card. But unfortunately, on checking the footages, it is found that all the footages were corrupted. Hence, the same could not be placed on record, Lordship. The fact that there is as per the police version of the police that these two accused persons went to one ATM in Laban and deposited in the money of the named person. But that has also not been corroborated, Lordship, because they are claiming that the footage is not there, Lordship. Now, this is he was arrested in August, Lordship, and already he is spent more than 8 months in custody, Lordship. And we have already moved, he has already moved 2 bails, Lordship. One bail, the first bail dated 21 January 2026, and second bail was 4th April, Lordship. 6th April, Lordship, which has been rejected by the Learned Special Court, Cleriat, which has necessitated the petitioner to approach this Honorable Court, Lordship. Lordship, there is another aspect, Lordship, which I may point out, Lordship. And Lordship has recently passed a judgment, Lordship, wherein the very important aspect of ground of intimation of arrest also has been covered by your Lordship. Here also there is a template. In the ground,
Have you,
Lordship. Yes, Lordship.
is there any averment to that effect?
Yes, Lordship. I made a word, my Lordship. Here, what has happened is that they in the ground of arrest, Lordship, only the template is there, checklist is there, and they have only marked the template. Who is that? Yes, I think this is the one. Yeah. Lordship will kindly come to. Yeah. Page number 79, Lordship. Annex 11.
$79.
79. Page number 79, Annex 11, Lordship.
Yes.
Here, Lordship, the heading is intimation of grounds of arrest, Lordship.
Yes.
To Mr. So-and-so, son of so-and-so, in connection with the case under reference in which you have been arrested, you are hereby intimated about the grounds of arrest as marked below, Lordship. Here is the third point, Lordship.
Yes.
Only the tick is there. You are suspect of being involved in cognizable offences punishable with imprisonment for a term that may extend to more than 7 years, whether with or without a fine or with a death sentence, Lordship. This is very, very, in my opinion, humble opinion, Lordship, this is very vague, Lordship. There are thousands of penal provisions which cover or which are covered under this point, Lordship. It is very, very vague. As per the law, the specific sections and the punishment which entail under those sections have to be intimated, and in the language he understands, the accused person understands. Here that has not been done. It is just a casual way of intimation, Lordship, and it is just a checklist, just a tick mark. There is no written which section, which act, NDPS Act, under which section and which punishment each attacks. That has not been done, Lordship. That way they have violated the well-established principles of law, Lordship, and on this ground alone, Lordship, I humbly pray that the petitioner will be enlarged on bail so that he may come out and prepare for his defense, Lordship. He has already suffered under more than 8 months of incarceration, Lordship.
My Lord, I'll do my best to justify my submission, my Lord, because I got the brief just now. What my learned friend has...
Depends on you. If you want time, it's going to give you time. But you cannot say, you see, that I'll do my best.
My Lord,
within the limited...
I think the law is settled on this ground taken by my friend, my Lord. Firstly, the ground taken by my friend is that the present petitioner's husband, Ravi, was arrested on the basis of the statement of the first accused.
Yes.
That was his ground, my Lord. So, my Lord, my learned friend's submission is that the revelation or the statement of a co-accused cannot be used for the purpose of arresting the subsequent. That is one ground taken, my Lord.
Section 67.
My Lord.
Section 67.
Section 27 of the Evidence Act, my Lord. That creates an exception, my Lord. Section 27 of the Evidence Act says that, my Lord, that so much of information given by the accused person, my Lord, that leads to the discovery, my Lord, of certain facts, my Lord, that becomes an evidence, my Lord, that can be used. Now, this is the case where, my Lord, the first accused was arrested, and arrested, not only that, he was searched in presence of the 2 independent witnesses, my Lord, and his statements were recorded. In his statement, he reveals the present petitioner's husband as the financing person, my Lord. So, my Lord, subsequent to that, the police leads a search party, and, my Lord, they come across the bank statement of this.
Just one minute. What is the stage of the case?
Lordship, it's fixed for evidence, Lordship. The complainant is yet to be examined, Lordship. Now.
No evidence has been recorded.
No evidence has been recorded. Complainant is supposed to be examined, Lordship, but due to some unavoidable reason.
So you've received copy of the charge sheet?
Lordship.
The complete charge sheet is here?
Complete charge is there, Lordship.
I don't know that. So, my Lord, now the statement, the disclosure made by the, my Lord, first accused, my Lord, led to discovery of evidence. That is the bank statement of the present petitioner's husband, my Lord. And not only that, my Lord, when the CCTV footage of the ATM, allegedly where this money was deposited via this ATM, my Lord, The present petitioner's husband was wearing a helmet, my lord, and his identity was, my lord, police had established it. That apart, the bank statement also shows that, my lord, that yes, indeed he was financing the whole drug cartel, my lord. So therefore, my lord, my friend's first ground saying that no, the revelation or the disclosure made by the first accused person cannot be used for the purpose arresting the present, my lord, second accused. But, my lord, section 27 of the Evidence Act makes an exception to the extent that if it leads to the discovery of certain facts, that much of the, my lord, statement can be used, my lord, for that purpose, and it becomes a substantive evidence, my lord, which is the case here. Now, second, my lord, the ground taken about the information, ground of arrest, my lord.
Yes.
So, my lord, I don't see any, my lord, because Lordship has noticed on the other case also, my lord, that about a week back, my lord, a charge sheet was being, copy of the charge sheet being, my lord, has to be produced before the Senate to justify or to, my lord, to find whether, yes, in terms of the, my lord, Supreme Court judgment, my lord, what are the criterias and the language which the accused understands, those things has to be, my lord, should be complied with, my lord. Apparently, my lord, in this case, my lord, I would like to, my lord, rely on my lordship's own judgment, my lord, which has clarified this very point, my lord. This is in the case of, my lord, Rubinus Ripnar, my lord. The same, my lord, ground was taken, my lord. I have a copy with me, my lord. My lord, before passing this judgment, I had relied on, my lord, the latest cantina of, my lord, Supreme Court judgments, my lord.
What is the, that is?
This is bail application number 38 of 2025, Robinus Ripnar.
Order dated?
Order dated 26/8/2025.
Lordship, if I may, Lordship. One minute.
Yes. You can.
Lordship.
My lord, I'm sorry, that was a misquote, my lord. This is bail application number 6 of 2026, order dated 26/2/2026, in case of Ronaldo Khongwir versus State, my lord. The relevant paragraph, my lord, is page 7, paragraph number 20.1.6, my lord, if I may read.
Where's the copy, Mr.
I'm sorry, my lord. There are 2 copies. I have my spare copy. Ronaldo Khongwir. This is my lord's judgment, my lord. If I may read, my lord, from page 6.
Para 20.
My lord, paragraph, page 6, my lord, paragraph 13 onward, my lord. My lord, I have replied, my lord, effectively to the first ground, my lord. This is the second ground. Paragraph 13, if I may read, my lord's own judgment, my lord. In support of his contention, the learned AG has relied upon the case of State of Karnataka versus Sri Darshan 2025 SEC Online, Supreme Court 1702, and has referred to paragraph 20.1.1, 20.1.7, which is reproduced herein below as. The learned counsel for the respondents accused contended that the arrest was illegal as the ground of arrest were not furnished immediately in writing, thereby violating Article 22(1) of the Constitution and Section 50 CRPC, now Section 47 of the BNSS. This submission, however, is devoid of merit. Article 22 of the Constitution mandate that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Similarly, Section 50, subsection 1 of CRPC requires that every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest. The constitutional and statutory framework thus mandates that the arrested person must be informed of the grounds of arrest, but neither provision prescribes a specific form or insists upon written communication in such case. Judicial precedents have clarified that substantial compliance with this requirement is sufficient unless demonstrable prejudice is shown. In Vihan Kumar vs. State of Haryana 2025 SSC Online SC 456, it was reiterated that Article 22 is satisfied if the accused is made aware of the arrest ground in substance, even if not conveyed in writing. Similarly, in Kisi Reddy Upendra Reddy vs. State of Andhra Pradesh, it was observed that when arrest is made pursuant to a warrant, reading out the warrant amounts to sufficient compliance. Both these post-Pankaj Bansal decision clarify that written individualized grounds are not an inflexible requirement in all circumstances. While Section 50 CRPC is mandatory, the consistent judicial approach has been to adopt a prejudice-oriented test. When examining alleged procedural lapses, the mere absence of written grounds does not ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of a fair opportunity to defend. The High Court, however, relied heavily on the alleged procedural lapse as a determinative factor while overlooking the gravity of the offence under Section 302 IPC and the existence of a prima facie case. It is noted inter alia that there was no mention in remand orders about the service of memo of grounds of arrest. Paragraph 45, the arrest memos were allegedly template based and not personalized. Para 50. The eyewitnesses had not stated that they were present at the time of the arrest or had signed the memos. Paragraphs relying on Pankaj Bansal versus Union of India and Prabir Purkasthya versus State of NTC, it concluded that from so and so onward, failure to serve detailed written and individualized ground of arrest immediately after the arrest was a violation entitling the accused to bail. In the present case, the arrest memos and remand records clearly reflect that the respondents were aware of the reasons for their arrest. They were legally represented from the outset, applied for the bail shortly after arrest, evidencing an immediate and informed understanding of the accusation. No material has been placed on the record to establish that any prejudice was caused due to the alleged procedural lapse. In absence of the demonstrable prejudice, such as irregularity is at best curable defect and cannot by itself warrant release on bail, as reiterated after the High Court treated it as a determinative factor while overlooking the gravity of the charge under Section 302 IPC and the existence of prima facie case. Its reliance on Pankaj Bansal and Prabir Purkasthya is misplaced, as those decisions turn on materially different facts and statutory context. The approach adopted herein is inconsistent with the settled is inconsistent with the settled principle that procedural lapse in furnishing grounds of arrest absent prejudice do not ipso facto render custody illegal or entitle the accused to bail. So and so, my lord. So on the question application, I'll come to my lord. So, my lord, with this observation, my lord, lordship, however, paragraph 21, page 11. So, my lord, here it has been decided, my lord, that in all the canon of justice, my lord, my friend has, my lord, mentioned before your lordship, my lord, it does not speak of a particular kind of, my lord, performer. It does not. So, therefore, meaning thereby, my lord, where? So, this particular ground of arrest, my lord, has to be looked into from a different aspect. That is, my lord, how the arrested person is prejudiced, my lord. Now, here in this case, my lord, the mere just by filing a bail application before your lordship amounts to the very fact that the arrested person is well aware of the ground of arrest, why he was arrested, for what offence he has been arrested, my lord. If any prejudice is, my lord, spelled out, then in that scenario, my lord, yes, the state is wrong. Police should have made it in such a way. But however, this is a case where, my lord, there are, of course, in a tick mark format, my lord. On the last occasion, lordship had expressed there should be a meeting between the police and the, my lord, team of government lawyers, so that we can, my lord, give them some kind of guidelines and all. But however, this is a case, my lord, where the petitioner has been herein. First thing, this is a heinous offence, my lord. This case was in case of, my lord, 302 murder case. That is an individual crime, my lord. It is not against the society, my lord. But here, this is a case, NDPS, my lord. Our state is, my lord, rotting, my lord. The whole society at large is rotting because of, my lord, this kind of, my lord, activities, the drug cartel, my lord. So thereby, my lord, taking a flimsy ground, that ground of arrest has to be written in a particular format and in a particular language, it is to be explained, my lord. That has not been set out by any precedents, my lord. That is my limited understanding, my lord. But here is a case, my lord, mere by filing this application, it has to be presumed that, my lord, that the arrested person is well aware about the nature of the offence he is alleged to have been, my lord. Now, that is my lord, submission to the second ground of arrest, my lord. So, my lord, in view of the, my lord, whatever I have submitted, my lord, this is a case, my lord, a very heinous offence, my lord, to the society. Society is rotting, my lord. The young generations are rotting, my lord. Now, taking a cue to, my lord, that particular ground that I was not given a written, Lord, that should not be, my lord, because my friend has to show how he is prejudiced. Nothing has been spelled in the petition, my lord. No prejudice is caused, my lord. If there is a prejudice, yes, my lord. That is my sum of my lord.
If I may reply, lordship.
Please.
Lordship,
Sorry.
with regard to the
first.
My lord, to the first ground, my lord, I have got a citation, my lord, where all the, my lord, latest Supreme Court judgments has been written, my lord, that is pertaining to, my lord, the statement of the co-accused, my lord.
What is the citation?
Citation is, my lord, this is the latest citation, my lord. Anand Jakkappa Pujari Elia Gaddar versus State of Karnataka.
Supreme Court cases?
My lord, Supreme Court. Criminal Appeal number 1864 of 2024. This has been decided here, my lord. A relevant paragraph will be, my lord, page page 37.
Hey, Mr. Guru, you have not given me a copy.
I'll give mine. Page,
You have a copy with you, you don't have.
and I have got a copy. Page 37 onward, my lord.
You should also give a copy to him. Always see. be
I have.
prepared. So that he can. He
Lordship.
has to refute when it comes to authorities. He has to refute. Paragraph.
37.
45.
Page 37, my lord. Page 37, paragraph 45. It speaks of discovery at the instance of the accused appellants, my lord. So, my lord. To sum up my argument, my lord. Lordship has to see whether any prejudice has been caused, and nothing has been, my lord, put forward in that direction.
If my lord allows me to reply, lordship.
Yes.
With regard to the first point, when my learned senior made submission,
Yes.
lordship, I'll reiterate that the accused person was arrested merely on the statement of the co-accused, lordship. And most importantly, there was no recovery made from him. There was no recovery of contraband, neither cash. So only on the basis of the statement made by the co-accused before the police, lordship, he was arrested.
You have any authority on that?
Lordship. So what has happened, lordship, here is that based on the police statement made before the police, he has been arrested. Now it was the duty of the police to corroborate the statement which he has made, if at all. Now they have the detail of the and Lord, my learned senior submitted that statement, account statement was accused person has been recovered. It is not the account statement of the accused person, but the account statement of the person in whose account the money was deposited. He has not been arrested. No investigation is going in that direction, lordship. If he had been arrested and produced, lordship, he would have, any statement made before the police has to be proved, lord. That has not been the case, and no recovery, neither contraband nor cash has been made from the person of the accused person, lordship. So here it was very, very imperative on the part of the prosecution to arrest the person on whose account money has been deposited. If that the version of the police is to be believed, he appears to be the mastermind of the whole case.
Where is that? Have you pointed out from your charge sheet? Where's the finding of the
IO, lordship.
That the money was deposited not in his account but in somebody else's account?
Yes, lordship. From ATM, because my learned lordship.
It is at page 26, my lord. Kindly come to page 26. And
Page number 26, lordship. I have already read it out. I'll again read it out, lordship.
At my lord, bullet point 6.
3, 4, 5, 6, 7, lordship.
Kindly 6 also, my lord. During the thorough interrogation, both the arrested accused person admitted they have deposited cash through ATM. So, my lord, on the subsequently, the identity of the, my lord, the present petitioner's husband wearing helmet in the ATM was established.
That is only the version of the police, lordship.
Exactly.
No CCTV has been.
That can be confirmed. That is the subject matter of trial.
Lordship. Let the trial go on, lordship.
Exactly.
I'll read that, lordship, for lordship's convenience, lordship. On perusal of the bank statement, it reveals that the accused person actually deposited cash.
Where is that?
Lordship, is the 6th paragraph, 7th paragraph, bullet point, lordship.
1,
2, 3, 4, 5, 6, 7.
6.
Page number 26, 7th.
I think my friend should read from bullet point 6, my lord.
Lordship, I will be the judge of each paragraph to read, lordship.
Whatever is suitable for him. From 6 onward, my
lordship, on the 7th paragraph, lordship, it's mentioned, on perusal of the bank statements, it reveals that the accused persons actually deposited cash on 17th/8/2025. They had deposited an amount of 1,15,000 only through ATM situated at Laban Junction, Shillong, in account number so and so, maintained in the name of one Salibuddin, village Panighat, PO Panighat, Sadarsi, PTI, Karimganj, in number so and so.
So he has not been made accused.
He has not been made accused. There is no investigation, lordship. Oh, he is the mastermind. It appears, lordship, because it appears money is deposited in his account.
Why he was not made accused?
My lord, that is my lord, at this juncture, my lord, if I may
charge
say,
sheet has been filed, lordship, and he is not made an accused also.
My lord had pointed out that, and now my friend is harping on that. My lord, that is not the issue here, my lord.
That is the issue, lordship.
I get it. My lord, here, kindly look at page 27, the note portion, the first note.
Yes.
Because his bail application is on 2 grounds, my lord. Kindly see, my lord, it is to be noted that around this time, the CCTV footage was scrutinized, checked, and it is ascertained that the accused person appeared in the camera at 10:01 a.m. till 10:20 a.m. The accused person, Sri Ravi Kumar Gupta, the present, my lord, the person, is wearing helmet, and Sri Niku Roy Mona is wearing a cap while they entered inside the ATM. Further, it is seen they are depositing cash. What more is required at this stage of bail, my lord?
Lordship, if I may humbly, Lordship, there's
my lord,
a saying
what
in
has
English,
been
Lordship.
pointed out why the main accused, my lord, has not made a party
Lordship,
in this case. If that is the fact, my lord, if that is true, my lord,
that paragraph has to be
stand
read.
can be taken during the trial.
That paragraph has to be read in conjunction with another paragraph, Lordship, because the devil, they say, lies in detail, Lordship. Here, it is to be mentioned that during the seizure of CCTV footage, which was stored in the pen drive, on being produced by the technician so-and-so, during the seizure of the videography and photography was recorded by so-and-so using mobile phone and is stored in SD card. But unfortunately, on checking the footage, it is found that all the footages were corrupted, Lordship. So I don't know, Lordship. That is the version of the police only, that he was wearing a helmet. Nobody has seen that.
What has fallen from my lordship about the main accused in whose account this money is deposited is not a made party. My respectful submission would be, my lord, that can be agitated during the trial, my lord. But at the bail juncture, my lord, his involvement, prima facie involvement.
Mr. Guru, the fact is that this court also has to look into the aspect of selectivity.
Absolutely, absolutely.
Whether the police are being selective or not.
My lord.
So only on that ground also you can assign prejudice. So that is why if his name has indeed appeared in this charge sheet, what is the noting? Whether he is whether he is not at all involved, whether all those things has to be there.
I pointed out, my lord. Kindly see the charge sheet, my lord. That he has been named. Thereafter, subsequently things are discovered. He is wearing a helmet. Enters the ATM, my lord. Establishes.
Yes, Mr. Yes. What is your authority?
Lordship, Lordship. This is Mihir Rajesh Shah versus State of Maharashtra, Lordship. This is a 2025 judgment authored by Chief Justice of India, Lord B.R. Govai.
What is the citation? That is on intimation of grounds of arrest.
Lordship. Here, Lordship, very important point, Lordship. The accused person understands Hindi, Lordship. In the charge sheet, it's mentioned. He understands Hindi. Language is not, it is Hindi. But even though there is no specific ground of arrest, it is whatever template is there, it's in English, Lordship. That also could be factored in, Lordship.
But what is the citation?
Lordship, this is 2025 Live Law AC 1066, Lordship.
What live law? Is live law a recognized journal?
Lordship.
When it ultimately reported, my lord, it's completely, my lord, two different things.
Lordship will kindly consider this time, Lordship, but next time I'll make sure that
give some
Lordship.
SEC online or
Lordship. Manupatra, Lordship.
Well, you see, you read newspaper all the time with this the issue of AI judgment.
Very dicey, man.
Lordship.
You don't know what is what.
I understand, Lordship. Lordship will kindly consider this time.
You try to find out in the meantime.
Lordship.
You try to find out that citation on Mihir.
Lordship. I will, Lordship.
I remember that case, but I don't have the citation to do.
I can't be helping him, my lord, otherwise.
No, that is on the issue of language.
Exactly, man.
Lordship,
language known to the is what.
Lordship, before parting, Lordship, I would just
read out. Relied on by me. That was my lord had authored it, my lord. And these things are discussed in detail.
Lordship, Lordship,
you have to look at the particular facts and circumstances.
Just before parting, Lordship, I would, Lordship, like to read one paragraph from Lordship, the judgment which Lordship has passed, Lordship, authored Libius Arang was State of Meghalaya, Lordship. Here, Lordship, the paragraph one, before parting, this court, having seen the format wherein the intimation of grounds of arrest have been drawn out, would observe that such format is contrary to law, Lordship. since it has been clearly indicated that specific facts have to be spelled out for the accused person to understand the allegations against him. Such kind of format is found not compatible. The authorities concerned would do well to rectify this situation, Lordship. Here, that template is there, no other ground intimation of ground whereas is there, Lordship.
As Mr. Guru has rightly observed, that will be the duty of the police or those in authorities,
Lordship.
perhaps with the government.
Yes, Lordship.
They'll sort it out.
In the meantime, my lord, at the earliest, my lord, we'll try to have a meeting with the police
Because
through AG, my lord.
this is not state specific.
My lord.
It's a pan-India.
Pan-India,
Exactly.
Lordship. Pan-India, Lordship. What was continued has been continued, Lordship.
Let Meghalaya
Nobody
be
had.
a model for that, my lord.
Meghalaya be a pioneer in this case, Lordship.
advised by our Guru.
My lord.
You didn't cite that judgment just now.
We have, Lordship, another judgment, Lordship. Lordship, Dr. Rajinder Rajan versus Union of India.
Do
And
one
another.
thing, you just give
Like,
it
yeah.
a list and citation. Do it in the do it in the meantime.
Lordship.
Deeply
I will supply the court.
I'll pass this to your orders.
Lordship.
Deeply
Deeply obliged, Lordship.
Supplementary list, item number 1 for pronouncement of judgment.
May it please your lordships. Lordships beg to mention item number 12. Lordship, in praying this matter may come up after 2 weeks, your lordship.
Is this
Shows that
records to be reduced?
Some instructions were sought for them. I believe they are.
Lordship, we need some more time, lordship. It would be better if Learned T.S. Chair will be here, your lordship.
2 weeks?
Yes.
12, 2 weeks.
Much obliged.
Please, your lordship. Lordship, item number 10, your lordship.
Two weeks.
Hello, your lordship. 10, sir. 2 weeks.
Please, lordship. Lordship, I beg to mention item 20.
20.
I think today no hearing item will be taken up.
My lord.
We'll pass the orders.
My lord.
Because my brother has got some engagement in the second half. And now it's not possible so to take up.
My lord. Deeply obliged.
Item number 2.
Just
Your Lordship, we just want to mention two items, items number 13 and 14, where we have filed the written submissions.
Hearing is concluded, written submissions have been filed on both the parties.
Okay. Matter to be reserved for.
My lord, yes.
Item number?
13 and 14.
13, 14.
Talk to
13, 14.
Written argument file. Matter reserved for judgment.
Much obliged, lordship.
Obliged.
On supplementary list, item number 2.
Paper book or admission.
Admission. Please, your lordship. Lordship, this case is fixed for admission, Your Lordship.
Noted.
Highly obliged, Lordship.
Item number 6.
6.
Lordship, there is a delay of 2,192 days.
Legal aid.
Delay. Legal aid matter.
Tell us how we can unknown delay of 6 years.
Lordship,
Any law?
the appellant has applied late after 5 years of. In 2025, he applied for LAC, and the judgment was passed in 2020. The imprisonment is 20.
What is his
20 years.
What is his
Lordship.
background? Is he illiterate? Is he educated?
He's a laborer, Your Lordship. Illiterate.
Delay control.
Daily list item number 1.
Obligation.
May it please your lordship. Paper book is ready. May it be listed for a hearing.
Will come after 3 weeks, Your Lordship, for hearing.
Why Mr. Kurushi is not here?
He's
the
under the
legal
court.
counsel.
The conducting counsel is on next, Your Lordship, in court room number 2, Your Lordship.
It has been submitted. It is submitted that the paperwork is ready. As such, matter to be posted for hearing.
After 3 weeks, Your Lordship.
This is the same according. This is the same. This is matter after 3 weeks.
Apply, Your Lordship.
It was just be very, idiots,